Hello, hello. Welcome, everybody. We are starting the last panel of the day. Yes. Hello, everybody. I'm Gloria Gonzalez Fuster, and this is the last panel, and you're sad because it's the last panel, but tomorrow there will be more, no problem. And this is called AI and Access to Justice. The next act is the panel with the young participants, so they are all healthy, they have no responsibilities, life is easy, they are all present here. That's the advantage of being young, you can attend the panel. And this is the next generation of researchers. It doesn't mean that you are obsolete or something. You are also fine. You are the current generation, and that is very good. So I'm the moderator. I will introduce myself briefly so you know who am I. I'm Gloria Gonzalez Fuster. I'm a research professor at the VUB, the Vrije Universiteit Brussel in Brussels. I have now a research position called Digitalization and a Europe of Rights and Freedoms. Basically, I'm supposed to be concerned with all the rights and freedoms that are impacted by digitalization. In practice, I'm very much obsessed with data protection law, and I have this argument that everything is connected to data protection law. All rights and all freedoms are connected to data protection law. Now, what's the connection between data protection law and this subject that we are discussing here at the conference? I see two main connections, and one, I saw it before, and the other one, I see it increasingly as important for me. One connection, we were discussing this in the previous panel, is, of course, how do we protect the data that we are processing to develop all these artificial intelligence solutions? That's very important. And another interesting type of question for me is how can we help with AI tools access to remedies in data protection law. So in data protection law in Europe, we have, but also in other places, we have this possibility to go to the courts to defend our rights, but also to go to administrative authorities, data protection authorities, and one should be able to lodge a complaint with an authority. Can this be somehow made easier, more effective through AI? For me, that's a very interesting question that perhaps they will help me address at some point, or you will help me address it at some point. We decided, because they are young and nice, they decided that it's fine that I will not introduce them, but they will introduce themselves. They all said yes, yes. So they will introduce themselves. And the idea is that there are three presentations, so one, and then a duo, and then another presentation. And they will have each around 15 minutes to present the paper. So these are papers that were selected, like quality papers. Will these presentations be quality presentations? There's a lot of pressure. The previous panel, people with a lot of experience, a lot of presentation skills, a lot of confidence. Is this easy to follow up? We will see. But I'm sure you will help them because the idea is that they have 15 minutes to present and then there's space for questions. And your questions are, of course, very, very important for this. Your feedback, that's very precious. So then right after the presentation, be ready with your good questions, then another presentation and another presentation. And if we have time at the end, we will just continue the discussion with everything that is left to discuss. Everything fine? Good. So I can just give the floor to the first person, and that's Camille. And so please introduce yourself. Thank you.
Thank you very much. First of all, allow me brief words of thanks to the organizers of this conference for giving me the precious opportunity to be part of it and to be back at the Cyber Justice Lab. Allow me to also thank Alexandre for overseeing everything so perfectly. Thank you very much. A few words now to introduce myself. I'm Camille Bordere. I'm a PhD student at the Université de Bordeaux in France, and I'm working on a comparative studies of the French and Quebec doctrinal discourse on AI tools in the judiciary. How many member states of the United Nations do not have the letter A in their name? Unless you are a big fan of quizzes, you probably ignore the exact answer to that question. What if, before I asked that question, I'd said that more than 5,000 kilometers separate Bordeaux in France from Montreal? Would your answer have varied? What if instead I told you that it took me 5 minutes to come here from my hotel room? In both cases, not only is the answer yes, but it's also a big yes. The difference of estimation after receiving different initial values is due to a cognitive bias that affects decision-making in uncertainty, the anchoring bias. At this point, you're probably wondering why I'm talking about cognitive psychology in a panel supposed to analyze the use of AI to increase access to justice. The answer actually lies in the questions. Who more than the judge is involved in a decision-making process in uncertain situations? So who more than a judge may be subject to the bias I just spoke of? As for the AA part, it is the best place to operate that bias. After all, most of the tools that offer quantitative analysis of past decisions produce numerical values. Average damages, success rates, likely amounts of allowance. Moreover, the sales pitch of the company that sell these tools also largely revolved around the promise of an increased access to justice, especially formal justice. The idea is that better informed litigants resort to justice in a reasoned and optimized way. Only when it is absolutely necessary, and if they decide to go to court with a clearer and more realistic strategy. We're used to discuss at length the benefits and the risk of those tools in either technical or more fundamental terms, just as we did this morning and this afternoon. We don't usually study their impact on the decision-making process in a cognitive sense. It's the path I'd like to walk you on to study the relations between those tools and access to justice. If we do admit that they affect physical access to justice, how much do they also affect the quality of justice? In other words, when these tools reach the courtroom, what is it that they do to it? I tried to answer that double questions in the time I've been given. I'll first present what cognitive bias are in general and what the anchoring bias is in particular, before I turn back to the judge and finally the interaction between that judge, that bias, and quantitative analysis tools. Whether we want it or not, a judge is, before all else, a human being. Even if his mission of judging other human beings is highly specific, his judgment itself is no less integrated into a web of logics, automatism, bias, actions, and retroactions. That framework of thought can be studied through the lens of its scientific discipline, cognitive psychology, that gave it a name, heuristics. Heuristic can be defined as the quick, automatic, and intuitive mental operations that guide and simplify human decision-making. They can be considered as shortcuts or even short circuits. They were first described in the economic field as to contradict the idea that humans are rational beings striving to make optimal decisions based on the full appreciation of all the facts they have at hand. On the contrary, it was demonstrated that human decision-making relies on a limited rationality, itself based on the cost-benefit logics. Humans will make good enough decisions, that is to say, decisions that are cost-effective in terms of cognitive efforts. As soon as a decision or an estimation is considered good enough, the appreciation stops, even if all the facts have not been properly considered. That demonstration, was the basis of subsequent work made in the psychological field, led by Daniel Kahneman and Amos Tversky. They, as well as other cognitive psychologists, conceptualize a variety of heuristics, the most well-known of them being the heuristic of representativeness, availability, and our main focus here, the heuristic of anchoring and adjustment. The way this heuristic works is fairly simple. When individuals have to make an estimate in a situation of uncertainty, they do so starting from an initial value that they adjust to produce their final answer. This adjustment step, however, is typically insufficient to cancel the anchoring effect of that initial value, so that different starting points yield different estimates, which are biased toward the initial values. This bias was first demonstrated in generic situations where subjects had to estimate a quantity in regard to more or less relevant anchors. The classical experiment had the subject spin a wheel of fortune, loaded so that it either showed a low value, 10, or a high value, 65. They were then asked to estimate how many African countries were part of the United Nations. The median number given by each group appeared to be strongly anchored by the initial value they received. 25 countries for the low anchor group, and 45 for the high anchor group. That experiment was then reproduced with the same outcome using the subject social security number, their phone number, a dice roll, a card draw, or even just the identification number of the experiment. That's one important thing to remember about the anchoring bias. It does not matter whether the anchor is relevant to the estimation or not, just as it does not matter if the subject is being expressly told just how irrelevant the anchor is. Two other characteristics of that bias. One is its resilience. It has been demonstrated that warning a subject about that bias, explaining how it works, or giving incentive not to let it affect their judgment, even financial incentive, has little to no consequence on the biasing effect of an anchor. Second important characteristic of that bias is that it does not only affect quantitative estimation, but also non-quantitative estimation. The experiment made using the identification number had the subject estimate their ability to perform a task, and that estimation was also affected by how high or how low the anchor was. At this point, we have reasons to worry. Does it mean that judges are always biased? And does it mean that they're likely to be influenced by any value given by some cunning lawyer? Obviously, other than us have asked themselves the same questions, and they gave it a positive answer. Like all other experts making decisions, the judge is apt to anchoring, even when the anchor is obviously irrelevant. Those studies have demonstrated that a criminal verdict in terms of years of imprisonment, the interpretation of a legal standard, and the amount of damages awarded are easily biased by an anchor, which can sometimes be the judge throwing dice before making his decision. So now we're past worrying. Does it mean that we can play dice with how many years a defendant will spend in prison, as my title suggests? Draw cards on how a legal rule is interpreted. The consequences seems overwhelming if we consider all the situations where a judge received potentially anchoring pieces of information. What about scales, reference frames? What about expert reports? And what about the rule of law and the fundamental principle of judicial impartiality and independence? So let's not just throw away our constitution, though not yet anyway, at least for two reasons. The first of them is that these experiments were essentially conducted in lab conditions, which means either using past written decision or organizing mock trials. Because we can't reasonably make any real-world experimentation to verify just how strong the anchoring bias is in the judiciary, we have to remain cautious with their conclusions. The second of these reasons, the most important one, is that these experiments did not stop at the very cynical conclusion that judges can never be impartial and are exposed to all kinds of manipulations from lawyers or prosecutors. Or rather, they drew all the conclusions from that fact. The parties, their counsel, and the judge's behavior has a paramount effect on the activation and the adjustment, and thus the mitigation, of the anchoring bias. Even though the first offer or demand of a lawyer, either high or low, is likely to anchor the judge's decision-making process, the opposing party's reaction to that offer can limit, and in certain cases cancel, the anchoring effect. To do so, they can either make a counteroffer or encourage the judge to change his point of view on the matter at hand so as to consider the opposite. In other words, even though the sheer awareness of the anchoring effect of an initial offer will not cancel it, the effort made by the judge to reconsider, rethink, and reevaluate that initial offer does have the effect to mitigate it. That awareness thus makes for the first step for all actors of a trial to seize on that bias, either to use it to their advantage or limit its effect. This awareness is also a key to understand and keep control of tools that offer quantitative analysis of past decision, especially those of them that produce averages, percentages, or probabilities. As such, a judge who either access or is given access to the information that a litigant may expect a particular amount of damages will be biased in his decision-making process, but just as he would have been if that amount of damages had been presented or asked without the tool. In other words, tools that offer quantitative analysis of past decision do produce initial values, anchors, but no more and no less than a scale, a reference frame, an expert, or a lawyer offer. It's precisely what authors point at when they highlight the risk of a prescriptive, normative, or ship-like effect attached to that kind of tools. The idea that they might influence the judge or the litigant in some undue way. Wherever the word used, it all comes down to that heuristic and its web of constraints it imposes on the decision maker. But like I said, the first step to mitigate this risk remains to be aware of it. Even if it's not enough to warn the judge or the jury that they might be biased, It is enough to draw all the conclusions from that fact and take all the necessary steps. Ultimately, it's up to the actors of the judiciary to take charge of this risk. If the party who is advantaged by this kind of tool would be wise to use it, the adverse party would also be wise to build their strategy on the contradiction of the value given by the tools or their reasoning. In that case, if the judge does decide to consider the opposite, his estimation process will be at least partly freed from the influence of the advantaged party's anchor. Of course, to affirm this would require specific experiments conducted using these specific tools. We can imagine that the anchor they create could be intensified by the fact that they are created based on other judges' decisions. Using that information could add mechanisms of social and professional conformity on top of the heuristics of anchoring and adjustment, especially in a profession that is used to base their decision on their peers' opinion. I personally do not know of any experiments of this sort, but I insist. They and the result they might produce could be the starting point of a strategy to counter the potentially perverse effect of quantitative analysis tools, either in terms of interactions with judicial impartiality or in terms of protecting case law's dynamism. So this is what we can keep from this cognitive lens of analysis of quantitative analysis tools. A healthy worry, bearing its own remedies, and ways to conceive a flexible set of limits to this kind of technological tools if they actually, eventually, fulfill their creators' promises. Oh, and by the way, there are 65 member states of the United Nations that do not have the letter A in their name in French. Thank you very much.
Hello. First of all, thank you to the Cyber Justice Laboratory for inviting us today to participate in the panel about AI and access to justice. I am Margaux Degen and I come from Belgium. I studied at Université de Brussel. I am now studying at Paris Panthéon-Sorbonne, specializing in IP and IT law. I am conducting a research project with Marco Tumaini that you see here that will introduce himself.
Hello everyone, I'm Marco Tumaini. I study statistics at the University of Bologna, and I would like to thank all of you for having us here today and discuss our project.
Yeah, so as you can see, our project is object the calculation of child support amount using machine learning. So the first question is like, how are you going to do that? And also, why are you doing that? We'll try to answer to these questions during our presentation, where I will introduce the background of our research, why we are doing this. Then Marco, I will give the floor to Marco we will present the methodology that we are following. Then present briefly the challenges and our insights, because we've been conducting this research for 6 months only, so maybe we are at the beginning, but we still have some remarks, let's say. Then I will present one of our, inspiration, which is Amica. It's an Australian tool that aims to help couples to separate smarter. I don't know if some of you already know this tool, but I introduce it to you. And then we'll generally talk about how machine learning can improve access to justice, in our humble opinion, of course. The background of the study of the research project that we're doing. Antoine Loisel, a French risk consultant, once said, "Who makes the child must feed them." Well, it seems easy like this, but when a couple separates, it's all about numbers. Maybe some of you know from personal or even family experience. There are currently in many countries 2 ways to settle down. Through a contract or before a court, or even in some countries before a public authority. We can see that in the OECD countries there is a clear divide between 2 kind of countries. There are the countries where the judge has the final competency of giving the final amount, where we can see that there are rather informal guidelines and a margin for appreciation. Then there are other countries where a public authority has the final competency, and that will normally find more formal guidelines. Why are we conducting this research is because also we have realized that statistical methods are already widely used in the field, They are based on averages or tables or sociological studies. For example, in my country, the country I come from, Belgium, we have 5 methods that are based on statistics. They are developed by practitioners, bar associations, or even some private actors. And we can also see that in Belgium, for example, this is already used by lawyers as a benchmark, and as well by judges. So, for example, the Renard method is very popular, and is also popular in France, also used in France. So we were thinking, there is obviously a need for a more personalized child support amount, because it's extremely difficult to take everything into consideration. And we thought that a machine learning model can help to calculate a fair child support amount. How are we doing that? By analyzing case law, like by extracting the data that we need and creating a model that would recommend recommend a child support amount that will fill the gap of the traditional statistical methods that we see that are being used. And we see, of course, the use of this model would just to be provide a benchmark for negotiation to the parties. So we see it as an online dispute resolution tool, and that we'll present a little bit more because we've been inspired by Amica, as we said, the online resolution tool from Australia. Now I give the floor to Marco to explain our methodology.
Okay, so the methodology has 5 steps. The first step is about identifying the features, so the X features that will allow us to predict fair child support amount. Then we move to case extraction, so we want to find a pipeline to extract case judgments by which we can identify those features. Then we want to do pre-processing the data, so we want to map raw data from raw data, a set of features that we can analyze. Then the model selection step. So we want to select a model that is simple, scalable, and most importantly, transparent. And then evaluation of the model step. So we want to achieve a good generalization result. And we want to iterate this process in order to continuously improve the model performances. So challenges and insights, we see right now from our experiment 3 challenges and insights. So the first one is data democratization, second one data standardization, and third one machine learning model transparency. About data democratization, the first characteristic is easy access to data. So if we have easy access to data, we can have more people that can analyze data and more machine learning projects. An example, so we use the API called Judiciary. It's an API released by the French government in summer 2022, and is currently in a beta version, but we use this API to query our data. So we want also easy data pipeline development. So here, in our case, so we are a team of 2 components, and mostly I do the coding part. And we were able to build a pipeline from scratch by using 2 different layers. The first layer is about search. So we have a keyword, we input a keyword in the system, and we search a set of judgments that are related to this keyword. And the second layer of our pipeline is about retrieving the judgment. So we are able at the moment to retrieve thousands of judgments and store in our systems in order to do further analysis. So this leads to more ML projects and innovation. Also data standardization. So we faced issues standardizing data. What I mean here, so data here is unstructured. We want to isolate, for instance, the child support amount feature in the text, in the judgment, and it's hard for us to find the section in which this amount is specified. Also, standardized templates. At the moment, we are able to isolate this feature, but we need to process case by case the numeric encoding of the number. So we would like to, in order to increase efficiency in our pipeline process, to have a standardized numeric format for the number, for instance. Also, machine learning model transparency. So in our approach, we want to avoid black box model. So we want to be able to explain the relationship between X and Y features. And by using a neural network or complex model, in my little experience, it's very difficult to explain this relationship because we have many parameters to optimize, and we cannot explain the relationship between features. So we want to choose a simpler model. For instance, a statistical model that, in our case, can provide an estimation of achieved support amount. So this would lead to increased trust. So we will be able to provide a solution that can be more trustable and can be more accountable for citizens that will use this solution. So give the floor to Margaux.
Thank you. So I have now I have to introduce you the Amica tool that inspired us. As you can see, it's a tool that is a smart and simple way to separate, even if it seems quite a peculiar sentence. But it has the goal to help the citizens to separate smarter by implementing different layers and different. And also they have different documents they have to fill in. The parties, they can communicate through the website, through the app, and they also implement in this tool AI by providing a recommendation for the distribution of assets of couple who separate. This tool has been commissioned by the National Legal Aid and Legal Aid Commissions in Australia. So we see that this is developed by a private company that is called Portable, a small company, works for Australian government. And we can see that the partnership between the private and the public sector seems to have worked pretty well here. Well, it's a quite new tool, so maybe we have to wait to know and to assess it very properly. But here you can see how they're also advertising it. Like you have a very user-friendly design. It's really aimed at the citizen in general. So I thought it was very interesting. Then I finished this presentation by sharing our views on how can machine learning improve access to justice in our opinion. I think that first we have to ask ourselves, what is justice? I know it's a big question that I won't really answer now, but is access to justice access to the institution of justice, or is it also access to what was previously called social justice or legal information, legal culture? We can call it however we want. Well, if justice is only have access to a judge and fair, I mean, of course, fair trial, everything. Well, in Belgium, a study has showed that the costs of legal proceedings can represent up to 300% of median monthly household income. So I don't know who can really afford that, but not many people, I guess. Then what is the solution? Is it to increase the costs, so the means, or reduce the cost of justice? This is, I guess, a highly political question that I won't answer as well. Then who can help? Lawyers, experts? Well, yes, of course, but they have a cost as well. And then the final question is, can softwares and tools help in certain fields that we would have selected, such as family law? I truly believe that this is a field where it can have a big impact and a good impact for families and couples. So as we already said, it's an alternative dispute resolution tool, and it can provide a benchmark to the citizen for negotiation and used as a reference for negotiation. So that's it.
So good afternoon, everyone. I'm a master's student. I graduated 2 weeks ago from the Masters of Law in Information Technology Law from the University of Montréal. Thank you, but and I'm very glad to be here with you this afternoon, and I thank all the team from the lab for allowing me to be here and present some thoughts. So very delighted to share some thoughts with you today about implementing AI tools in the public administration, which was a topic we recently started to study in the lab. So it would be nice to present our the last things we developed and have some suggestions and thoughts from you in order to help us to have a better insight. So there is no doubt that the promises of artificial intelligence for the future, but also its results, which we can already touch, are bound to reshuffle the cards in a vast field of disciplines. And law is no exception, as we have insight from discussions. Moreover, the objectives of the development of AI tools in the field of law aim at a better access to justice. And the access to justice includes, in particular, the decongestion of courts by improving the speed of proceedings. It also includes a better access to legal information for all citizens, but also many other aspects, such as the reductions of costs for citizens as well. So our first observation is that very often, and rightly, a better access to justice made possible by AI would concern above all the sectorial development of AI tools in the legal field. In this respect, we are thinking of the use of AI in legal text and its promise of effective access to the law, which in turn will improve access to justice. For instance, many private players have developed AI tools to support the legal practitioners, such as BlueJ Tax or case law analytics. And there are also AI tools directly designed to provide legal information to citizens in an automated way. And this is the case of JusticeBot that we developed here at the laboratory. Nevertheless, it should also be noted that development of AI solutions that can provide assistance in a variety of different fields could also contribute to better access to justice. For example, the prowess of language, whether it be translation tools or tools for summarizing text, is echoed in almost all sectors of activities. These common tools are used in the private sector, but they tend to develop within the public administration at the service of the agent who represents public administration, but also of the citizens. Indeed, and this is the second observation that guides our reflection, more and more AI tools are being implemented in the public administration. And a study that we conducted in the laboratory shows that more than 90 AI tools in 4 different countries, it shows that this deployment is taking place in many areas of public administration. And obviously the most represented sector is the police and the fraud sector. And the justice sector, on the other hand, is not necessarily well represented in terms of AI tools. This wave of AI deployment in the public administration, whether it is in the presence of specialized AI tools or common AI tools, should also irrigate the justice sector by helping administrative agents in their work. If this is the case, we believe that it could contribute to better access to justice. Based on these observations, the study of the improvement of access to justice by AI should also be measured according to the degree of implementation of AI within the public administration of justice. This should take into account that the dual influence of artificial intelligence that has been described, so specialized tools on the one hand, so it means that AI tools directly applied in the field of law, and common tools on the other hand, so we mean general AI tools facilitating the work of the public administration in the field of justice. And the double question to be answered would be the following. First of all, what is the potential of implementing both specialized and common AI tools in the public administration of justice to help administrative workers? And the second question, would it have an impact in improving access to justice? In our opinion, artificial intelligence in the public administration of justice at the service of administrative workers could truly support a better access to justice, whether one is in the presence of tools specifically tailored to legal issues, or whether one uses common artificial intelligence tools. Therefore, our study would focus on the implementation of these two segments of AI used in public administration in order to show how the implementation of AI tools in the public administration of justice can objectively contribute to a better access to justice by responding to a wide range of issues related to it. For the purpose of this presentation, we'll present two cases. A scenario of a common tool that, when implemented in the public administration, could contribute to a better access to justice, and an example of a specialized tool used by the public administration and that participates already to a better access to justice. So when it comes to the use of common AI tools that can contribute to a better access to justice, we necessarily think of a more general implementation of AI tools in the public administration. On this implementation, L'Université Laval has produced an interesting report to study the integration of AI tools in 3 different services in the Quebec public administration. And this is a good starting point. These AI tools concern more specifically voice-to-text transcription tasks during phone calls between administrators and citizens, automatic processing of citizens' requests, and facilitation of access to administrative information for citizens. The beneficial effects can be seen as the improvement of the relationship between the administration and the citizens, for instance, in the increase in the speed of procedures. If we take the case of the tool for automating the processing of requests, it allows for an almost instantaneous response to requests compared to manual processing. As for the voice-to-text transcription tools, they allow to reduce, for example, the duration of the calls between the administration and the citizens, which in the end leads to a greater volumes of calls that will be treated. And we will discuss the information access assistant tools and specialized tools for law and justice in the second part with the example of JusticeBot developed at the laboratory. The AI tools in public administration presented by this study could be transposed in the field of justice. Let's take, for example, the voice-to-text transcription tool. The implementation of this tool within the court clerk offices for what concerns the supply of information to the citizen, whether it is on the legal procedures or the paths to be followed for the deposit of such or such document, could completely find to apply. Let's imagine, for example, the information officers of an administrative tribunal whose call center is saturated with requests from citizens. In such a case, a voice-text transcription tool could help reduce the length of a call and ultimately contribute to a better access to justice. For instance, there are phone calls basically in all the tribunals, but for instance, at the Commission d'Accès à l'Information in Quebec, that is an administrative tribunal whose mission includes protection of personal information, but they can also be found at the Tribunal Administratif du Travail, which offers a general phone number for each branch of the tribunal, as well as the phone number of legal technicians for more specific questions. So the use of the phone as a means of access to justice and its services remains a very important one. As such, it would be very interesting to study the impacts of the implementation of AI tools to support the agents or the clerk answering the phone, and more precisely the benefits of such tools in view of a better access to justice through the gain of productivity for the court agents and eventually for the citizens. Now let's talk about an example of a specialized tool that we know well here. This is JusticeBot. And the JusticeBot was subject of a specific presentation during this conference cycle, so we won't go through into the substance of the tool or how it works, but simply mention it as an example of the implementation of specialized AI tools in the public administration. Indeed, it is used by the Tribunal Administratif du Logement in Quebec and serves to distill legal information in an automated way on conflicts between tenants and landlords. It is a tool that is resolutely in favor of access to justice, since anyone can now have legal information about their personal situation. This allows people to avoid having to call an agent when their situation does not require it. Consequently, this can be seen as a first step in relieving the course of providing citizens with the legal information. Thus, the agents over the phone would remain to answer the most complex requests, and maybe in a better way. The surveys and response to JusticeBot questionnaire show something interesting. The overwhelming majority of JusticeBot users learned about it from the Tribunal Administratif du Logement. This represents 71.4% of the users. One reason this data is interesting is that it shows that by implementing this AI tool into its landscape, the public administration of justice is itself redirecting the flow of requests for information to this tool. This contributes to lighten the burden of the administration's employees regarding the request of the citizens and allows de facto a better access to justice. While this improved access is quantitative, it is also qualitative. Indeed, the statistics on the use of JusticeBot since its deployment are good. In particular, the satisfaction rate of users is high, which means that they find answers to their questions and that the information given is of good quality. As such, 57% of users feel that the tool provided them with the information they needed to understand their situation. And 85% of users would recommend JusticeBot to someone they know. Thus, not only would a specialized AI tool like JusticeBot reduce the workload of administrative agents, but it would also provide good information to citizens. It does contribute to strengthen the relationship between administration and citizens while improving the quality of service. But there are some challenges and limitations that we identified. Indeed, implementing AI tools in the public administration of justice is not synonymous with excessive automation. Indeed, we are rather in the perspective of augmented intelligence, which supports the administrative agent's work. The results are promising in terms of access to legal information insofar as this is the most favorable and maybe easiest way for the integration of AI tools in the public administration of justice. In this respect, we have seen that the use of AI tools for voice-to-text transcription could find a concrete and efficient application. In the same way, the JusticeBot, from the results we have, is also an effective solution to support the public administration of justice. However, there are some challenges and limitations, I would say. And let's take, for example, the AI tool for processing an automated request. There are known situations in which this tool is very effective. The first one that comes to mind is the request for a criminal record extract. In some countries, such as France, you can get your extract in 2 clicks without having to interact with the public administration or public administration agent. In the field of public administration of justice, it is more difficult to find a situation in which such a tool could be implemented to support administrative agents in their work. The next step could be to look through each segment of the work in the public administration of justice and see if the implementation of such or such AI tool would be relevant, always with the idea of helping the administrative agent in their work. More generally, we must keep in mind that AI tools are not harmless and that they must be handled and implemented with care. Thus, when they are not necessary to improve the service provided to the citizen, they shouldn't necessarily be considered as a miracle solution. And for the rest, an approach based on the level of risk of implementing such tools should be adopted, and of course, this presupposes a by-design approach to eliminate these risks. So in conclusion, common and specialized AI tools are complementary. Implemented in the public administration of justice, they could really improve access to justice. The example taken today focused in particular on the request for legal information from the courts. But we must think about the level of implementation in the public administration that responds to other problems concerning access to justice, but while keeping in mind the risk inherent of the use of these tools in public administration. Thank you very much.